Right, so let's get going. Morning, everybody. I'm Mike Wright. I'm the Director of Communications and Membership at Bond. Delighted to be here today with you all and with our long-term partners, Russell-Cooke, who've provided lots of advice and support to our members over the last year in terms of thorny legal issues and other sort of representation and reputational issues that that our members come across. So delighted to be working with Pippa and Carla from Russell-Cooke today. Just a brief introduction from me. The main part of this session will be recorded and shared online, but we're not going to record the Q&A section because we wanted to give you the chance to ask open questions and have a frank and confidential discussion about the issues that you're raising. If you have questions, please ask them throughout the webinar as they arise. Drop them in the Q&A box at the bottom of the screen, and we'll come to those at the end of the webinar. Resources will be made available for all attendees and we'll give you the contact details for Russell-Cooke after this event. And we will share a survey link, so please rate the event and tell us, about other events of this type that we might look at. So I'm going to hand over to Carla. Is it first, or is it Pippa? Pippa.
It's me. Hi, I'm Pippa Garland, partner in the charity law team at Russell-Cooke, specialising on governance matters in particular. And I'm very pleased to be here with my colleague Carla Whalen, and thank you to the Bond team. So before we get into the legal framework, I wanted to set the scene for why these issues feel so acute for NGOs now. In many respects, disputes around values, identity and belief are not new. So why are we doing this talk? We feel the context in which they now unfold is dramatically different. And that's why we're finding them across our desks in our work, but also across our desks in the media. NCVO published a really interesting report in December last year, exploring the impact of the rise of extremism and social division on the voluntary sector. I know that a lot of this is not going to be a surprise to any of you. Across the 5 listening sessions that NCVA held, participants talked about the rising levels of fear, intimidation, and online hate sparked by division and polarisation. And I know that as Bond members, the areas in which you work are often at the front line of this. It's even now driven engagement from the regulator, and the Charity Commission focused its annual public meeting on charities facing an age of hostility. In some cases, charities have actually had to ask the regulator to anonymise trustee details for safety reasons. So some of the themes that we've seen in our increasing engagement in this area as advisors is that social media is really amplifying everything. Information is spreading quickly and sometimes inaccurately. People feel pushed to take a position quickly and publicly. Reactions posted in the heat of the moment can create real and lasting consequences for organisations. We're also seeing an increase in coordinated litigation, often encouraged by campaign groups and supported by fundraising networks. Organisations such as the Good Law Project have increased this a lot, as have crowdfunding platforms that are designed to support litigation. NGOs can quickly become the target of online pylons, media scrutiny or donor pressure, and that has a real impact on staff, volunteers, trustees and beneficiaries. This is including times where we've seen charities facing doxing of their staff, and in the context as well of charities that support refugees and migrants facing unprecedented levels of abuse. From the governance angle, we know that trustees have an obligation to ensure the safeguarding of everyone that comes into contact with their organisation, and there's increasingly a focus about protecting your staff and volunteers. Some of the impacts that we've seen include operational disruption and silencing, organisations cancelling events or reducing online visibility and scaling back public activities. We've also been involved in governance issues created by internal tensions within organisations. Grappling with conflicting views among staff, trustees and volunteers can have a really destabilising impact on an organisation, even when it only stays internal. Where it becomes public, it can also have a massive impact on the reputation of the organisation and divert even more precious resources in dealing with it. Our aim today is to help you navigate this climate. Carla is going to first talk through the key cases that have developed to tell us how courts expect organisations to balance competing rights. I'll then look at how similar issues have played out for charities in practice, what the Charity Commission expects, and what you can do practically to try and reduce the legal and reputational risk. So now over to my colleague, Carla.
Thanks, Pippa. And for those of you who were here right at the start, if you heard Michael talk about a slight delay because of technical issues, that's completely down to me. I'm not quite sure why, but I've had to join you via my phone today. So apologies if what you're seeing on the screen isn't quite as polished as it would normally be. I can't actually see myself on the screen, but I hope that you can. So I'm going to take you through what will be quite a quick whip through some of the key kind of legislation and then recent cases. The idea today is not that this is primarily a technical update. We haven't got time to look in detail at all of these cases. Some of you might know some of them quite well, and you may well know that I'm missing out quite a lot of the parts of the cases because they're very detailed and they look at a range of different things. The idea really in the next sort of 20 minutes or so is that I will give you a flavour of how the courts would expect you to approach these kinds of situations where you have clashes of beliefs. And we're going to look at two principal parts to that. One is the cases on the right to manifest your belief, and the other is the cases on services, facilities, and particularly single-sex facilities or services. So on the slide here, first of all, just starting with the basics. In the UK, the Equality Act is the main piece of legislation that will govern these cases. And that's because there's a protected characteristic in the Equality Act for beliefs. And that is, as the slide says, any religious or philosophical belief, including a lack of belief. Now, philosophical belief doesn't mean that it has to be, like in a book. There's a thing called the Granger test. Granger is just the case that established that test. And there's a range of tests, but it has to be something that's sort of a belief that's genuinely held, that it's serious. And in particular, the final leg of the Granger test is that it must be worthy of respect in a democratic society, and it must not be incompatible with human dignity and not conflict with the fundamental rights of others. Now, for a long time, people thought that that meant that things like, for instance, gender critical beliefs, which might, depending on exactly what the belief is, might stretch to someone saying that they don't recognize that trans people are, for example, women. For people thought, well, that does conflict with the fundamental rights of those people to identify as trans women. So surely those can't be protected beliefs. Recent case law really has confirmed that the test is much higher than that, and actually I think rightly so. Otherwise there'd be quite a dangerous silencing of views on the basis that somebody else really doesn't like them or finds them offensive. So the range of things that can be protected beliefs and will be protected beliefs is very wide, and really you have to get to something that is so offensive. So the case law talks about Nazism. There was one case in 2024 where someone had a belief in English nationalism that in their case stretched to really vehement anti-Muslim beliefs that were so unacceptable that they didn't pass that Granger threshold. But really, I think you should approach these cases on the basis that people's beliefs are more likely than not, to be protected under the Equality Act. So all the things we're talking about today will be necessary for you to take quite seriously in order to be able to defend yourself if someone claims that you have breached their rights. The second thing on here, the ECHR, so that's the European Convention on Human Rights. And the reason why this is important is, if Ollie can just put up the final bullet point, is the interaction with the Human Rights Act. So the Human Rights Act says that public bodies, and that includes the courts and tribunals, are under a duty to interpret domestic legislation in a manner that's consistent with the convention. So you have this quite strange layering where the Equality Act is UK legislation, but because of the Human Rights Act, the courts have to interpret it with the convention rights in mind. So in these cases, we see a lot of people also referring to the convention rights. I've put Article 9 on here, which is the absolute right to hold a belief, countered by the restricted or qualified right to then manifest that belief. And a lot of what we'll talk about today is about manifestation. Sometimes these cases also refer to Article 8, which is the right to respect for private life and private and family life, and Article 10, the right to freedom of expression. But that's kind of laying down the basics for you. So if we are talking about convention rights, you kind of understand how they come into play in these cases. So on to the next slide. What I'm going to look at, as I said, is really quite a quick review of recent cases where these laws have been applied to really quite tricky situations, sometimes in the workplace, sometimes more in a services context, where people's beliefs have either clashed with other people or have led to them being denied a service. There are many, many more cases, but the ones I've picked, I think, help us to kind of build a picture. So the first one is a really important case that went through the courts on appeal right up to the Court of Appeal, and the judgment came out towards the beginning of last year. So this one is the case of Mrs. Higgs. She is a Christian. She was employed by a secondary school. She was pastoral administrator and work experience manager. And I think some of the time that pastoral role, people had kind of key in their mind here. The head teacher received an email from a parent complaining about a Facebook post that on Mrs. Higgs' Facebook page. Now, her page, as I understand it, was private, but this parent was connected to her. She'd reposted something that was from the US, and it was pretty inflammatory. And she'd reposted it with, "Please read this, they are brainwashing our children." And the post was encouraging people to sign a petition about the teaching of same-sex marriage, same-sex relationships, and gender in schools. There were also some other examples of sort of not dissimilar Facebook posts, again, most of which she was sort of reposting and commenting on. Because of the complaint, she was suspended, she was disciplined, and ultimately she was dismissed for gross misconduct. The school dismissed her on a couple of grounds: breach of the code of conduct. They said the Facebook posts used inflammatory and quite extreme language. She was dismissed because of the parent who'd complained taking offence, therefore saying that meant that her post was offensive, and because of the potential risk of harm to the school's reputation. Now, in short, for the purposes of today, the school was unsuccessful in defending that dismissal decision as being proportionate and justified in all the circumstances. Now, it doesn't mean that she shouldn't have been disciplined. It doesn't mean that this wasn't a breach of the code of conduct, for example. What the court was really looking at here was the proportionality of the decision to dismiss her summarily for gross misconduct because of this Facebook activity. Now, Lord Justice Underhill in the Court of Appeal said this was unquestionably a disproportionate response. And he said that because he said the posts were not grossly or gratuitously offensive. So coming back to that Granger test that I talked about, it's a pretty high bar here. Yes, he said, the language in those posts passed the threshold of objectionability. They were objectionable, but they weren't grossly offensive. So you can see that the bar might be a bit different to where we might have otherwise thought it. There was also no evidence at all that the reputation of the school had been damaged. She was effectively dismissed because there's potential for reputational damage, but there was no evidence that any had occurred. There was also no evidence that her work had been affected or would be affected by the views expressed in her posts. That was her personal Facebook page. As I say, it was actually a private page. And otherwise, she had an exemplary record, disciplinary record, and she'd never exhibited any discriminatory attitudes towards pupils. She also said in the disciplinary that she wouldn't impose her views on others. She would use pronouns if people wanted her to. These were just her private views that she was expressing in her private life. So focusing on that proportionality of the action taken, and given those convention rights that we talked about are engaged here, the court suggested that there are probably three relevant factors for an organisation to take into account in these kinds of cases. First of all, what is the subject matter of the manifestation, and how relevant is it to the work that the organisation does or the individual's job? Obviously, the closer the relevance, the more serious it will be. Secondly, what's the way in which those beliefs were expressed? Again, that threshold of offensiveness being really very high in order to protect the right to freedom of expression. And whether those views are personal or whether they could be imputed to the organisation, here at the school. And I think, these are all so fact specific. I think if she had been the head teacher, it might have been different. But she wasn't, and she was relatively junior, and there wasn't really any, in the court's view, suggestion that this represented the views of the school, or that the school would be teaching those subjects in accordance with her views. So I think what we get from this case, and this is a really important one, is a sort of reset really on the idea of inclusion and what that means in terms of us living in a pluralistic society where we have a tolerance of diversity of belief and we respect that right to freedom of expression. Those rights can only be curtailed when it is really proportionate to do so in the circumstances. So I think, you know, absolutely, it might have been that there would be a proportionate response would be giving her a warning, for instance, but it was that level of, you know, just you're gone, completely disproportionate here in the view of the Court of Appeal. So on the next slide, just looking at a couple of other cases that have kind of come alongside that one. This one you might be familiar with. Alison Bailey is a barrister, and she is a barrister at Garden Court Chambers. She brought a case against Stonewall, and the others in the title there is Garden Court Chambers. So in short, what happened here is Ms. Bailey was held to have two protected beliefs under the Equality Act. The first one, a belief that women are defined by biological sex rather than gender identity. And the second one, that what she called gender theory, as promoted by Stonewall, is severely detrimental to women. She gave some reasons why. So she held those beliefs, and she was tweeting effectively about things related to those beliefs. Stonewall run their diversity champion scheme, which I think has actually been renamed now, but at the time that's what it was called, and Garden Court was one of their diversity champions and part of that scheme. So Stonewall got in touch with Garden Court to say, have you seen what's on her Twitter account? And what happened that was really difficult for the Chambers in this case is that they publicly tweeted that they were going to launch an investigation into complaints about what she'd said on Twitter. And obviously, you know, barristers, they're self-employed, their reputation is all about their public profile. You know, that was quite a serious thing. And so she brought claims. The tribunal agreed that Chambers had directly discriminated against her. Chambers tried to argue that their tweets weren't because of her beliefs, but because they needed to, quote, damp down the Twitter storm. So what they tried to do is separate the beliefs from the reason why they took the action they did. And this is sometimes called the separability principle. And there's lots of case law where organizations have tried to argue it's not because of the person's belief, it's because of the way they manifest it, or the way that they express it. And really, with some limited exceptions, it doesn't fly. And here it was because there's such a close connection between the beliefs that she holds and the controversy that arose as a result of differences of belief. So it couldn't be disassociated. It was also held to be victimization because some of her tweets were protected acts under the Equality Act, i.e. she was alleging that Garden Court or Stonewall had themselves breached the Equality Act. So she was raising claims of discrimination, and she was punished as a result of raising those kinds of allegations. The other thing to say about Alison Bailey is that she brought claims against Stonewall, which were not successful. What she tried to say is that because Stonewall had complained to Chambers, Stonewall was discriminating against her because it had caused or induced discrimination against her, or it had attempted to. And I think rightly, the tribunal rejected that. She appealed it all the way up to the Court of Appeal. And just quite recently, the Court of Appeal agreed and said, no, you know, it's an organisation in Stonewall's position, a complainant can't be guilty of discrimination because they made a complaint and then Chambers decided how to investigate it and what to do. You're allowed to make complaints. You're not then responsible if the organisation, you know, sort of messes up how they actually investigate it. So, you know, you can see sort of the balance of two things happening there. I thought I would give you on the next slide an example of a case where actually it's gone the other way, where the organisation in question has been found to have been justified in taking the decision they did. So this isn't an employment case, this is a services case. So this is Manchester City Council received a fostering application from an evangelical Christian couple, the Smiths, and The Smiths held views that homosexuality and abortion were wrong, and they also held gender critical views. And they indicated to the council that they would tell a foster child in their care that homosexuality was a sin and a choice. And the council felt that, you know, that meant that they would find it difficult to promote diversity, and that was one of the criteria for their fostering applications. So they turned them down. And the couple brought a claim saying that this was because of their beliefs that they had unjustifiably been prevented from fostering. And again, this went to the county court because it's a case about services, not a case about employment. And then it went on appeal up to the High Court. And the High Court found the council had not directly discriminated against the couple. It was a policy decision. It wasn't just saying that no one who holds these views could possibly foster. They did look into it. They properly heard the couple. And it was because of the couple saying, no, that's what we would tell a foster child. You know, we wouldn't present this as a balanced decision for the child to take. We'd tell them it's a sin. And it also held that the council's decision was objectively justifiable in terms of interfering with their rights to hold and express those beliefs because of what they had said about how they would manifest those beliefs. And then just before we move on to a slightly different topic away from manifestation, the final one I wanted to give you on the next slide is the case of Adams and Edinburgh Rape Crisis Centre. And I think this is a sort of interesting one, not because it's a particularly it's just a tribunal decision, so it's not binding. It's more interesting on the facts and almost a bit of a cautionary tale. So Edinburgh Rape Crisis Centre had an occupational requirement of only recruiting women and a policy of supporting women, trans and non-binary people. So they appointed a new CEO who was a trans woman, and at that time it was particularly relevant that she didn't have a gender recognition certificate. So clearly stepping outside of the kind of occupational requirement, although this is pre-For Women Scotland. So, you know, it may have been that the Rape Crisis Centre believed that she was a woman for these purposes. We'll come on to that in a second. I think the point that we really need to recognise is that this was very much a live issue within this organisation. Mrs. Adams became concerned with the organisation's approach to gender identity, and that differed from her beliefs. Now, what happened one day is that a service user asked Miss Adams what the gender of one of her colleagues was. And that's because the colleague had been put in touch with the service user, and the colleague was using a male name. Now, there was no policy or guidance for staff on how to deal with this kind of request. So Mrs. Adams sent around an internal message and said, how should we respond to this? I think I should say that the colleague was born a woman, but now identifies as non-binary. So the CEO emailed Mrs. Adams' colleagues in response to this and said that Miss Adams had humiliated her non-binary colleague, that they would not be working together again, and basically implying that she was transphobic. Now, there was then a disciplinary process, but really those CEO's comments had just kind of prejudged the fairness of that. It was pretty clear that from the outset, that was going to be the decision. She was dismissed for gross misconduct. She appealed, that failed. At tribunal, probably quite unsurprisingly, the centre was found to have discriminated directly and indirectly against her and harassed her, mainly because the organisation, again, couldn't justify the disciplinary treatment as being justified in the circumstances. I think what happened here as well is the tribunal was, you know, really quite critical and made comments that the CEO believed that gender critical beliefs were inherently hateful, and that had influenced her decision to take disciplinary action. And I think, as I say, this is just a really cautionary tale, I think, for us to be really strict at all times, and it's much easier said than done. When these cases arise, we don't allow our own beliefs on these subjects to interfere. And when we're appointing people to investigate and look into these things, that we think carefully about who is going to be capable of investigating, because those clashes of beliefs might just quite naturally arise. And it's a big ask to say to someone who holds a strong belief on a topic, you need to put your belief aside. So I think that is a really good case to just keep in mind as to how it can be really tricky if you have people that hold very strong beliefs and are supposed to be conducting a kind of objective investigation into an issue. Okay, so that's where I'm going to stop on the cases relating to the manifestation of beliefs. I think if we could pull together any little thoughts that we might pick up on in the discussion, you'll really see here that the focus is on the proportionality of the decision and the reasons why the decision was justified in all the circumstances, rather than just focusing on we don't like your views, or things like your views don't accord with our values. Now, I think that's something that we might talk about later, but the threshold is quite high to just say you're not allowed to say that. You've got to be much more nuanced about why, what's the impact, and why has that impact meant that what you're going to do and the action you're going to take is justified. Okay, so moving on, I'm just going to spend another sort of 10 minutes or so before handing over to Pippa on cases which will probably be very familiar to you, if only in name, because they've had so much attention in the media and frankly in the sector as well, for very good reason. You'll see on here there's a quite ambitious attempt to put 4 cases on one slide. I'll not go into the detail on these. Again, it's a sort of flavour of where things stand right now on the legal front. So probably everyone here will know that the Supreme Court gave its decision in April last year in the case of 4 Women Scotland. Now, in some ways, this was actually quite a technical decision on a question of statutory interpretation. The question was, what do the terms sex, man and woman mean in the Equality Act? And the court held that they refer to what it called biological sex. Now, slightly unhelpfully, they didn't really tell us exactly what they meant by that, but it was pretty clear from the judgment that they meant the sex that someone was assigned at birth. Now, that raises, as we all know, quite a lot of technical and practical questions and challenges, many of which just remain unanswered still at this moment. And that's why there is so much focus right now, and why I've put on the slide these 3 very recent tribunal decisions. Again, they are just at tribunal level, they're not binding, but they do show us how the facts of a case and the approach taken by an organisation can make the difference between something being lawful and justified or not. Anyone who tells you that there is a black and white answer about things like access to facilities, what you must do and mustn't do, hasn't really grasped the complexity of this, because these cases show it can be on a knife edge depending on how you're justifying things and what you've taken into account. I think 2 things to say about 4 Women in Scotland. Firstly, second paragraph of the judgment, the court is really clear that it is only adjudicating on the meaning of these words in the context of the Equality Act. It is not talking about how those words are used in the public domain. It says, our purpose is not to define the meaning of gender or sex or the word woman other than as it's used in the Equality Act. And then separately, the other thing that is clear is that if you are an organisation that's relying on the single sex exemption for services, let's say, for women, or if you are a charity that has the exemption to limit your objects to women or to men, you will need to take a different approach if you want to include trans women and trans men in those services, or you want to do work that includes them. And that's because in that case, it is really clear now that the single sex exemption that allows you to have a service just for women means biological women, because it uses the term women from the Equality Act, and the Supreme Court was clear about what that means. What is really important, though, is that you don't have to offer single sex services. So it's not mandatory. It is effectively a defence if somebody brought a claim saying that they've been excluded from a service because of their sex. So you would lose that defence, but there might be other ways to justify it. So it's not straightforward. What these cases listed here, Kelly, Peggy and Hutchinson and others, are about are the really difficult decisions that organisations, employers, facilities are facing right now about those policies in terms of access to facilities and services, and the dilemma that even just applying this from a legal perspective, if you exclude trans people, they might bring a claim, for example, a harassment claim, saying that that's, forcing them to use facilities that don't accord with their chosen gender is a hostile, degrading, humiliating, offensive kind of environment for them. Conversely, if you allow trans people to use the facilities that accord with their chosen gender, you may well get sex discrimination claims from cis people. So it's not straightforward. These cases, that first one, Kelly and Leonardo, that was one about an employer that permitted access to workplace toilets based on asserted gender. So what I'm going to call, for shorthand purposes, a trans inclusive approach. On the facts of that case, that did not amount to unlawful discrimination or harassment. Similarly, and I think I'm going to spend a little bit more time on Peggy because there's a few helpful morsels that we can grasp hold of for guidance from this one. It's really similar kind of situation, but this time related to changing rooms. But this was where the NHS, well, the health board in Scotland, had a trans inclusive policy in its changing rooms. Mrs. Peggy, Sandy Peggy, was a nurse. She held views that sex is mutable, that trans people are not entitled to use women-only spaces. She complained, hospital investigated, and ultimately she then brought discrimination claims. The tribunal, because these happened after For Women Scotland, they're some of the first cases where we've seen the courts grapple with what For Women Scotland does mean and what it doesn't mean. And here the tribunal said, For Women Scotland doesn't mean that Sandy Peggy's rights, her convention rights, automatically have priority over the rights of her trans colleague. They both have protected characteristics under the Equality Act, and it's about balancing those rights. So applying that balancing approach, the tribunal here said it may be lawful to permit a trans person to use the changing room that aligns with their gender, as long as the specific circumstances are taken into account. And these are the morsels that I mentioned. The examples the court gave of the circumstances that might be relevant are views of other staff expressed to the employer. Is there lots of people in support of it? Is there lots of people against it? What the trans person's wishes are, the stage of the trans person's transition and how the trans person appears to others, and other options for other facilities as well. Now, I'm not pretending all of those are easy things to grapple with, but you can kind of see the approach the court's taken. So here it had been lawful in the view of the tribunal to give the trans doctor permission under the policy to use the female changing rooms. Once Sandy Peggy objected, though, the court said what they should have done is revoked that permission on an interim basis while it considered alternatives. And then they said the policy actually became lawful again when the solution the hospital came up with was putting Sandy Peggy on a different rota to the doctor, which meant they wouldn't have to share the changing room. So it's really that different facilities approach. Now, a word of caution, these cases will probably all be appealed. So this is just to give you an illustration of the approach that the tribunals are taking to For Women Scotland. The final one here is just to illustrate that point that I made about this one went the other way. It's almost exactly the same facts as the Peggy case, an NHS trust with a changing room policy that permitted a kind of trans-inclusive approach. Here, several female nurses brought claims together. The difference here, I think, is that the trust couldn't show that its policy was justified. It hadn't really thought about balancing the competing rights, about respecting the gender identity of all employees and respecting also the views of the claimants. What had actually happened here is that the tribunal said the trust just hadn't taken their concerns seriously at all. It had just declined to address them. And instead, it had suggested that those women needed to be educated on trans rights and broaden their mindset. Now, that obviously made them feel dismissed at the very least and made them feel that they were seen as transphobic. So you see that it's really important, that objectivity that I was talking about, recognizing, even if you don't agree with a view, that people have the right to hold these views, and they have, albeit a limited right, to manifest them. So you can't just say you're not allowed to have that view. You need to educate yourself. Okay, so just to finish up before I hand back to Pippa, on the next slide, you will be aware that coming out of For Women Scotland, that's what I mean by FWS at the top there, coming out of For Women Scotland, the EHRC, not to be confused with the ECHR, the convention, the EHRC, which is the Equality and Human Rights Commission, the body in the UK, did a consultation, a sort of further mini consultation, because it had already been consulting on updates to its services code in light of the decision. That updated code was submitted to government back in September. And I won't go into why, we don't know exactly why, but there are some hints, but it kind of has just sat there. And then really recently, just last month, we hear that actually it's probably going to be reviewed as a result of the EHRC getting a new chair. That was at least reported in The Guardian. And separately, in the meantime, what's bothering a lot of charities, particularly those ones that have objects that are limited just to women and girls, let's say, is that, you know, are they acting outside of their objects as trustees if they continue to take a trans inclusive approach? And the only, again, morsel that we have is, as many of you might know, the consultant Penny Wilson wrote to David Holdsworth at the Charity Commission an open letter about this. And he published an open response, which you can find on the Commission's website. And in that, he has said, firstly, that the Commission, are updating their own focused guidance on this. They've already carried out preparatory work where that's possible. And as soon as the new EHRC services code is published, they will seek to publish their updated guidance as swiftly as possible. And then secondly, again, kind of some comfort. In the meantime, their regulatory approach is that to accept that it can be reasonable for trustees to take a decision to await the final statutory guidance, or they can seek legal advice relevant to their charity's position, and they can make changes if they want to. But I think it's that first point that a lot of charities were asking us. We don't want to make a decision that might be wrong for us before we know what the new code says and what the Commission's approach is. So a bit of comfort there in an open letter from the head of the Charity Commission saying that they're not going to take regulatory action at this point if charities are going to continue to just wait and see. So final slide. Again, I think these are probably more points for perhaps returning to in the discussion. So you will have seen all of this playing out, I'm sure, in the sector and the national press. But I mean, there's a part of me that wonders whether Girl Guiding and Women's Institute are kind of annoyed that David Holdsworth has just published that letter and that the Commission didn't say this, you know, a few months ago. But for whatever reason, but both organisations, as you'll know, have made decisions to change their policy, to change, to have a kind of biological sex approach rather than a trans inclusive approach, meaning that, you know, only biological girls can join the Girl Guides. Now, I'm not going to make any comment on those decisions themselves. I mean, I think, you know, it's clear that they were considered very carefully by the boards, and that apparently they're, you know, extensive legal advice, I think they said in their statements. What I think is a little bit uncomfortable in these is both of those statements you see is this kind of with regret against our, you know, preference kind of sentiments coming through. And we really have no insight as to why they felt that they had to take that action right now, even though we don't have the code. There's been some suggestion that it's because they were all getting threats of litigation from groups that believed For Women Scotland made it very clear what they needed to do. And that might be the case. Now, obviously, the irony is they've now faced a bit of a backlash and perhaps potential claims. So Pippa mentioned the Good Law Project earlier. I think the day of Girl Guiding putting out their statement, Good Law Project was saying, if you've been affected by this, let us know, presumably looking to bring some kind of test claim on behalf of a trans girl who's been excluded, for instance. And I think just to finish, contrasting that approach that Girl Guiding and Women's Institute and probably others have taken, contrast that with the approach taken to access to Hampstead Ponds. So as you might know, Hampstead Ponds is run by the City of London Corporation, and the corporation did a consultation which ended up being huge. You know, tens of thousands of responses, of which I think 80+% were in favour of just maintaining the status quo, which is a trans-inclusive approach. And separately, the group of charity, Sex Matters, brought a case, or tried to bring a case in the High Court, challenging Hampstead Ponds for continuing to have this policy. That was unsuccessful, but on quite a technical basis, in that it was brought in the wrong forum. It should have been brought in the county court, not the High Court. But also, I think for our purposes here, it was premature because this consultation that Hampstead Ponds were doing was still ongoing. Now, that does mean that we might not have seen the end of these challenges. I wouldn't be surprised if Sex Matters or other groups are doing what the Good Law Project has done, encouraging individuals who've been affected to come forward, and they will fund a test case. But the High Court's thinking really almost reflects David Holdsworth's point in his open letter, which is, yes, it is all still quite uncertain, and it's okay to be thinking about this carefully, to be waiting for the code of practice, the services code, to be doing consultations, to be testing views. And again, as reflected in those tribunal cases I just mentioned, the Sandy Peggy one, for instance, where, the factors that might be relevant when deciding that it was justified to keep, to maybe drop the single sex exemption if you're using it, or in the case of Hampstead Ponds, to keep having a trans-inclusive approach, might be because you've done a consultation and you can demonstrate that the views of the people, the relevant people, whether that's staff, members, service users, are overwhelmingly in one direction, not the other. So I'm going to stop there because that's a huge amount to cover in a relatively short time. And I'm going to hand over to Pippa, but hopefully there'll be some food for thought when we come to the discussion.
Thank you, Carla. So Carla's covered the legal tests that apply when beliefs clash, and I wanted to connect that to what we're seeing in practice and the sorts of pressures that NGOs are experiencing in real time and sometimes coming to us for advice on. So across the sector, I think we're seeing values colliding with operational decisions, often in unexpected places. Internal disagreements becoming public and escalating rapidly and leading to governance issues. Coordinated complaints and open letters, sometimes from opposing sides of the debate, all increasing the reputational risks, including threats of litigation or regulatory referral, and social media pylons often targeting named individuals. I wanted to illustrate with a few recent examples, although I'm very conscious that some of you in the room are living and breathing some of these examples and have much more first-hand knowledge. Obviously, I'm also constrained with what I can say in terms of client confidentiality. So I've picked some of the ones that have already gone public. So World Vision, I think, is one of the examples from our sector, which has been facing tensions and Charity Commission engagement around what appears to the outside to arise from some of the types of conflicting views that Carla's been discussing, with kind of organisational Christian values, staff activism, and internal culture and staff issues becoming highly public. There was a case again that made the headlines with the East London Mosque, where they excluded women from a charity run and led to questions about exemptions under the Equality Act. Save the Children UK had a high-profile example where a campaigns manager in a TikTok video kind of asked about recommendations for anti-Zionist bagel shops on a trip to New York, which I think was a good example of kind of personal content on a social media situation escalating quickly, where it interrelates with geopolitics and organisational identity and values. Last year, the Commission disqualified the trustee and voluntary CEO of the Palestinian Refugee Project over divisive and inflammatory social media posts relating to conflict. Importantly, the regulatory action wasn't only about the expression itself. It was also led on to looking at a combination of governance failures, lack of oversight and conflicts of interest, and the absence of a social media policy. So again, a good example of how personal expression and organisational governance can collide. We've seen charities facing complaints from lawyers against Israel, but we've also seen charities essentially on the other side of some of those debates facing complaints from the other side, and in both cases leading to regulatory involvement. Zooming out a bit, looking at US NGOs, particularly those working in civil liberties or reproductive rights, they're facing an unprecedented level of political and donor-driven scrutiny. And I think it's always, unfortunately, a useful bellwether for trends reaching the UK. I think the phrase is, the US catches a cold and we catch a flu. So I think keeping an eye on what's happening there is always useful. I think although each example is very different, the pattern's quite similar in terms of the fallout. Often it's the decision process itself that attracts as much scrutiny as the ultimate decision. So they share common values, common features, I think, the values colliding with operational decisions, internal disagreements becoming public and regulatory, and regulatory, media and donor scrutiny following quite quickly. I think why this pressure matters, it creates personal risks to staff and trustees, reputational and operational distraction, and a chilling effect on governance decision-making. I think it's important to acknowledge how destabilising this can feel for boards and leadership teams when they're navigating it, but also to note that trustees' legal duties still apply under pressure, and silence, speed or delegation without oversight can all increase risk. So moving to the next slide, I think looking at where the Charity Commission may become involved, often through several different ways. Something we're increasingly seeing is public complaints. So these can sometimes be coordinated by groups. And the Commission, it really was a focus at the annual public meeting. Both the chair and the CEO touched on this. The chair made the comment that they won't be weaponised, they won't be used, but both of them really did focus on, we will look at every complaint. And that is what we have seen. And, I think it shouldn't be underestimated. A letter comes from the regulator, even if they don't immediately launch in with a more formal engagement, any regulatory engagement such as that is taken very seriously and immediately leads to resources being diverted in dealing with that and ensuring that it doesn't escalate. So I think that means, you do need to be prepared. Even what feels like quite a spurious complaint can trigger questions that take time and resources to answer. And second, good governance is your shield here. So a clear paper trail showing how decisions were made is the single most effective protection when it comes to this regulatory engagement. Sometimes we're seeing involvement stemming from serious incident reports, but really interestingly, the Commission did reveal that actually only 1.6% of serious incident reports that are filed with it result in the Commission taking further action or further engagement with the charity. So we don't think that's the main reason why these things are coming to the regulator's attention or engagement. Finally, obviously, anything that happens in the media, the regulator will tend to get involved. So moving on to the Charity Commission's approach, I think what we have seen, what they've said publicly, and also what we've seen when we have engaged with them, is they generally are not concerned with what the decision trustees reach are. They always talk about trustee decisions falling within a reasonable range. And actually that range is quite broad. So what the Commission is focusing on is how the decision was made. The key questions they ask are always going to be, did the board understand the legal framework? Did it consider the risks? Did it take advice? Is the decision clearly linked to the charity's purposes and objects? And that's always the key focus. Was any communications handled responsibly? Is the approach consistent with past statements and values? And can you explain why this decision was proportionate? I mean, one key thing to note here is the importance of records. We've seen when we've engaged with the Commission what feels sometimes like a slightly unrealistic expectation of what gets discussed and minuted at board minutes, at board meetings. Often it will be, can you provide the board minutes where this, in the scale of things, small event was considered or tiny partnership was discussed, because you can't predict at the outset necessarily what things are going to lead to the regulatory engagement. And it wasn't discussed at a board meeting because it was just business as usual at that point. What we've fallen back on when we don't have board minutes, it's been really helpful to have written policies to point to, and clear delegation powers. So, for example, we've dealt with one charity that came under fire. There were complaints made about a hire that it had made of its venue that was then used for a fundraising for Gaza campaign. Being able to point to a hire policy was really helpful in that scenario, because obviously the boards don't discuss each of the 200 hires that happen across the year. So you can't provide the board minutes that are asked for, but you can point to other records and supply those to the Commission. I also wanted to mention here that the 2025 refresh of the Charity Governance Code, which I think is again relevant, the elements of ethics and culture in that emphasise behaviours, tone and ethical leadership, which is particularly important when navigating these highly polarised issues. Equity, diversion, inclusion now emphasises kind of inclusive decision making, not just representation. But essentially what we're seeing from the Charity Commission is an expectation that boards are able to show clear reasoning, purpose-linked decision-making and proportionality when navigating belief-related issues. Again, it's really not concerned with which path it took, but whether the board understood the legal framework, identified the relevant risks, took proper advice, and can explain how it aligns with the charity's purpose. Poor process is far more likely to trigger regulatory action than a controversial but well-reasoned decision. So, moving on to some practical steps that organisations can do to reduce risk. Governance and people, going back to basics here, but the training of boards and senior staff on rights relating to belief and expression, again, keeping records of that so you can, if you ever ask, say they were attended on these dates. Codes of conduct, potentially strengthening those and including expectations for respectful internal dialogue. We found things such as the Charity Governance Code update being a useful prod for organisations to have a look back at some of those. Policies and communication, having a clear enforced social media policy, setting out what's acceptable for staff, volunteers and trustees. The Charity Commission brought out guidance on that, so there really is an expectation that they are required to have a social media policy in place, have rolled that out across the organisation and probably have board meeting minutes where the trustees have improved that. Developing a communications framework for external statements, so criteria for when a charity speaks publicly and who approves those statements. And where we've seen charities run into issues is ensuring consistency across issues. So if you speak up about one geopolitical crisis but not the other, you can really get yourself into problems. So, for example, we had one client where they'd spoken up around the Iranian protests. They were a women's rights organisation, but then had a massive backlash because they weren't speaking out when the Israel-Gaza conflict started. Positioning, again, being explicit on the organisation's remit, scope and limits. If you are a registered charity, saying that, and setting expectations early with beneficiaries, members and supporters. So none of this will totally eliminate risk, but it avoids surprises and kind of ensures that decisions are deliberate, explainable and internally coherent. So just leaving you with final 3 points on this final slide. I think firstly is that risk can't be eliminated, but it can be managed. Secondly, that silence is not necessarily required, but decisions must be deliberate and grounded in purpose. And thirdly, that we're finding there really isn't any entirely neutral ground anymore, but what there is good governance and using that as a shield. So where kind of law, governance and values are aligned before the crisis hits, organisations are better positioned to navigate what comes next. So that's the end from me and Carla, but I think we were going to now have a Q&A with that part of the presentation not being recorded, but I'll pass back to our hosts at Bond who are doing the housekeeping.